In this episode, the elephants talk privacy, proof and dignity as they discuss Justice Lee's decision in Lehrmann Higgins, the full federal court's dismissal of the Ben Roberts-Smith appeal, and the freshly minted statutory tort of breach of privacy. We hope you enjoy the joust.
Welcome back to Elephant in the Courtroom, the elephant in the courtroom, in fact. I'm here with my esteemed colleague Awais Ahmad, coming to you from Morris Byers Chambers today. We've got a great show ahead. We revisit the Ben Roberts-Smith matter, Lehrmann Higgins case.
Yes.
There's been changes to there's a new statutory tort of privacy come into effect only in this past week, Vasi.
Yes.
There's been more tweaking of the bail laws by the state government. There's a new AI practice note issued by the Chief Justice of the Supreme Court, and of course there's been a change to the position with the judicial immunity aspect of the Stratford decision.
There has. Not to mention the Family Law Amendment Act kicking off yesterday.
The Family Law Amendment
Throwing
Act.
practitioners into disarray once again.
So plenty going on. Just us today, Vasi.
Yes.
No interviews subject for now, but there's still, as I say, there's plenty to talk about. Vasi, just starting with the Stratford decision, that's obviously in your arena, being a family law practitioner. What's gone on there?
Well, you would remember that we talked about, I think, season 1, episode 1, we talked about the Federal Circuit Court, the Federal Court considering that the Federal Circuit Court and Family Court Division 2 was a court of inferior record, and as a consequence, judges who sit in that jurisdiction, they are not immune from suit in circumstances where they do something or act in a way that was outside of power.
And just to refresh us, what did the judge do in that case?
So the Honourable Salvatore Paul Vuster, a judge of the Federal Circuit Court, sentenced a man known as Mr. Stratford. That was a pseudonym. He was sentenced for contempt of court in circumstances where the court found that the manner in which Mr. Stratford was treated and his sentence was constituted by many egregious errors and was, to use a legally technical term, outside of jurisdiction because he didn't have the lawful authority to sentence him in the way in which he did. As a result of a finding that he made summarily that Mr. Stratford hadn't complied with his duty of disclosure in the family court.
So in short, he breached a duty of disclosure order one too many times, as I understand it. The judge got fed up and said, "Righto, it's off to the slammer for you."
That's right.
And then obviously Mr. Stratford took the case elsewhere, and a judge decided that that was not only an incorrect decision, but it was a decision for which Judge Vuster was culpable in damages. Is that right?
That's right. When we talked about it last, the conclusion was that a judge was not immune from suit, i.e. they could be sued in damages for false imprisonment. And there was this, like anyone else, but there was this distinction drawn, an arcane description, I think Justice Edelman described it as in the High Court decision, about this difference between inferior courts
and superior courts. An inferior court being the Federal Circuit Court, a superior court being, for example, the Supreme Court of New South Wales.
But in short, they said if you're an inferior court, then you don't have immunity. But if you're a superior court, you do have immunity. What the High Court has effectively settled, they've said there's no distinction in practical purposes between an inferior court and a superior court. That's
for the purpose of judicial immunity.
Just in general.
Okay.
Proposition 1, at least, that's as far as Justice Edelman and Justice Stewart went so far as really getting into why we have this distinction. But specifically for the appeal, they made it very plain that any judicial officer purportedly acting in exercising a judicial function is immune. So for Judge Vuster and all the other judges out there,
they breathe a great sigh of relief.
They breathe a sigh of relief, and they can do things as they, acting with their judicial oath as they wish, without fear of a damages action. So that's an update on Stratford.
What about bail? Government seem to be always tweaking the bail laws.
There's constant tweaking to bail, but that mostly stems from what I understand to be political motivations and reactions by the community as they're sort of distilled up the radio presenters or the media about people that are out. But on the youth offenders, and do you want to tell us about that?
Oh, well, in short, my understanding is that they've introduced an additional threshold that needs to be met with respect to sentencing repeat youth offenders. A youth offender is someone from deemed to be someone between 14 and 18 years old, and this applies in respect somewhat narrowly in respect of youth offenders who are already on bail, who commit a particular type of offence, which is car theft and serious indictable break and enter. And so the thing is that there seems to be a picking up of a pattern whereby youths who have committed these offences already are being given bail, are out in the community and recommit those same kinds of offences. So my understanding of the recent change is that it's quite narrowly restricted to there needs to be a high level of satisfaction, in short, for the judge to grant bail in those circumstances.
And now, in addition to that, they also tightened bail with respect to those accused of domestic violence offences.
Yes.
And so they've made it harder. If you just go back a step, like the Bail Act was significantly reformed, Nick, in 2013. I remember coming to the bar and being around for a year or so and getting my head around this the crime jurisdiction and looking at the Bail Act. I believe it was 1987 was the pre-existing act. So the first time they really reformed it was in 2013. And they went to this trouble of, widespread consultation, and they did a number of reforms. But it was perceived to be by the community to be too friendly to the accused. There was a spate of high-profile releases.
There's always been that perception, though. Anything that gives a focus on civil liberties as opposed to making punishment more draconian is always perceived to be, and that's why it gets obviously politicised, because it's seen to be a weakness and enabling people who shouldn't be to remain on the streets.
But and then I think
the perception
is, and I think there's a tendency that it's low-hanging fruit for the media and politicians to grab on to every individual case that might be perceived to be a lenient outcome because the facts are abstracted in a certain way in the media. So in 2013, they had this massive law reform, put a lot of effort into it. Half a dozen people got released in circumstances that the community wasn't happy with. Immediately, pretty much overnight, I recall, they introduced this element of show cause. They doubled down on bail, and it became really difficult to get bail. And so, interestingly, again, we're now in a world where politicians and the media have, given attention to someone releasing, and the Chief Justice has finally spoken out about it, and to his credit has released a pretty big statement about it.
Yeah, the Chief Justice Supreme Court.
The Chief Justice Supreme Court. And basically,
Chief Justice Bell,
he makes the point that I think a lot of people lose sight of when they just see a headline. And the point that he starts off by making is, he says, Supreme Court justices deal with over 3,100 bail applications last year, while magistrates in the local court determined almost 40,000 bail applications. So what do you do with these circumstances where you have a clogged up system of people on remand waiting for charges that they might ultimately be acquitted of, but then incarcerated at the expense of the taxpayer and the government?
Well, isn't it this idea also that there's this sort of nanny statism going on where if I was a judge and I was faced with the situation of a youth offender who was already on bail for the very offence he then or she then commits, one would obviously have to think very seriously about re-granting bail. But yet the legislature is telling judges, you must satisfy this seriousness threshold. This effectively, you need to think very seriously about this. And in my view, to the point of the Chief Justice, is these judges are seeing cases all the time, granting bail all the time. They're mindful of all of these things. Or refusing bail. And we've spoken to judges here about the difficulties in doing that and the multifarious factors with respect to sentencing. Similarly with bail, I mean, there's obviously a number of factors which go into a grant of bail.
But yeah, I think as former Chief Justice Alsop said to us, that it's easier to comment and critique if you don't have to do it. And when you're tasked with the position of doing anything that involves judicial discretion that has serious implications on the liberty of an accused and the protection of the community, it's a delicate act. And
nuanced.
It's a nuanced act. And what the Chief Justice says, where an offence is committed by a person who is on bail, it is both wrong and unfair to attribute blame for that outcome retrospectively to the judicial officer who granted bail.
So, because there was the big thing when Lint happened, which is obviously an utterly tragic outcome. The judicial community was affected by that. The legal community, should I say, was affected closely by that with Katrina Dawson tragically. But one of the big things is there was Man Monis, the perpetrator in that case. He'd been granted bail.
That's right.
There was a microscope placed on his grant of bail because he had some sort of relevant form that, with the benefit of hindsight, certain pundits, not everybody, was saying he ought not have been granted bail, and that if that hadn't happened, well, all of this, if he hadn't been granted bail, of course, Lint wouldn't have occurred. So, I mean, there's always those isolated incidents with the benefit of hindsight, all of this that goes on, where suddenly the judicial officer who granted the bail is sort of made to look, well, you've done something, and that's unfair. And I guess,
and sometimes when I see the responses to perceived deficiencies in statute, I just think so many of the responses are just for the sake of it. The laws are there, they're not always, it's their application that requires consideration and appreciation. Not always is there a problem with the legislation. And because then what happens is you get to a point where, and I think this is a point Margaret Caneen made when we spoke to her, that the legislation just gets continually filled up with policy objectives, and you lose sight of what the spirit of the legislation is designed to do.
And of the individual circumstances that each case presents. And that's the hard thing, is the more the legislature steps in and says, well, it's got to be done this way, the judicial officer already has a difficult task. They've got one more thing to consider. So it's, there's interesting issues that arise out of that. Now, Vasi, there's been some big decisions, some very, I suppose, media exciting decisions handed down in the past 2 or 3 months, namely the Ben Roberts-Smith appeal, the Lehrmann Higgins appeal, and then, of course, you've got without just in shorthand referring to it as the mushroom criminal trial at the moment going on.
I just think it's fascinating. I mean, I think we're at a point where the public interest in litigation is really at an all-time high, and I think the courts are doing what they can to provide greater transparent access to these cases. I think we talked last episodes about the effect of live streaming trials. I noticed that on the mushroom murder trial, the accused Erin Patterson is charged with 3 counts of murder and 1 count of attempted murder in respect of a family, which I'll speak to about in a moment. But there's a daily podcast on that with lots of views. It's being held in a small, discreet town. The trial in Victoria. People are driving from all over the country, I'm told.
There's a feed on the Sydney Morning Herald.
Yeah.
But is this any great difference to, for example, what happened? I mean, obviously you've got the media there and you've got the instantaneous, the ability to get things out there instantaneously. But the fascination in, say, the Murphy trial, the trial of Justice Lionel Murphy that we spoke about with Judge ex-Judge Walmsley, the people are always going to have this level of fascination with these kinds of cases because they have this personal drama to them, and a lot of them are sometimes, better. Take, for example, Justice Lee's judgment in the Lehrmann Higgins matter. That makes for as good a reading as any great sort of page-turning novel. I mean, not to mention its length. It's a some 350-page.
I think I read somewhere
judgment.
That people have. This was certainly not sanctioned by the federal court, but people have created hardbound copies of it, and it's being sold at bookshops.
Well, it's fantastic. I mean, some people said they thought Justice Lee had gone a little bit far with some of his. I mean, to use the term loosely, flourish in certain parts of the judgment. I think quite the contrary, and in keeping with the argument, which I was somewhat against when we spoke about this, is that coverage of these trials, the live coverage via video link is, and Judge Walmsley thought this, that it's good for educating the public about how these cases go and obviously, again, the nuanced nature of litigation. Yeah. And so in keeping with that, Justice Lee's judgment, part of the reason for its length is there's a great deal of explanation and quality of reasoning, clarity of reasoning, which we all know is part of the test for, obviously, a challenge to reasons, is part of letting the defendant know why they've lost, is the great test. Well, but also really educate. It reads like you could take it as a short text on defamation laws.
Well, I mean, he's gone to considerable effort in preparing a very detailed judgment and gone to considerable effort in identifying some of the principles, and I think he definitely did write it, as I understand it, with a view to giving the public, given the significant interest, as an education as to why he's found his way, what the process of reasoning is, what the persuasion, why, how he needs to be persuaded of a certain fact.
And so let's make it interesting as well while we're there, if you're going to go through and read it. But there's some great references.
The first thing that stuck to my mind about that judgment when it came out was when we were talking about this in an earlier episode about why people who have the serious risks in bringing a defamation action in circumstances where your conduct is being impugned and truth is being raised by the defence. And the great line is that, at least in Bruce Lehrmann's case, having escaped the lion's den, he went back for his hat.
Did you know, I actually was curious, I thought that the whole lion's den thing was a biblical reference. It's actually an African proverb.
Is that right?
Yeah, it is, about going, it goes more so, the African proverb apparently, why go back to the lion's den to get your hat, sort of thing. Yeah. If you've got out of it, why would you bother? What's the point of going back for something like your hat?
I assume in your bedroom shelf at home, Nick, you just have a bunch of African proverbs.
Well, no, I do. I've got a whole book of them. No, but the hat, it's a great metaphor, because the hat is your dignity. See, this is when Justice Lee uses these things, and what I like. Your hat, that you're going back to the lion's den, of course, the litigation being the lion's den and the risks of a kill, so to speak.
But what did he escape?
But the hat is the dignity. He must have gone back for something, Mr. Lehrmann, and it appears that he went going back for his hat. That's what's so apt. Was he wanted to go back for his dignity, because he must have thought he wanted his reputation.
That's quite a.
I'm presuming that to be the case.
That's quite meaningful, Nick. But the way I read it was that having escaped the having escaped the serious ramifications of a criminal trial, he decided to go back for something as simple as his hat. But you're saying dignity is not so simple. It's in fact something worth fighting for.
Well, I guess, of course it is, and that's why would people go to these lengths? Why would Ben Roberts-Smith go to that length? He's obviously had some support financially, but why would you put yourself through it unless that was something that was really important to you, that you feel that you had been taken from you by the media? Because I wonder why it is that people would go through this. It's incredible. I just while we're on Justice Lee's judgment in Lehrmann, I really, there's a couple of other crackers because this whole idea, did the judge need to go to this length and put this colour and light and shade in it? But they're all very well selected little metaphors and references. Well, and a couple of them, just a couple. One of them was regard to the CCTV footage. You'll recall there was CCTV footage of the bar room.
Is this the first bar?
Where they would, the first bar, where they were drinking beforehand, and obviously there was a question about Ms Higgins' level of intoxication and
how many drinks Bruce Lehrmann had bought.
All that sort of stuff. In fact, there's a table in the judgment based on the cross references to the evidence of how many drinks had, who bought them, and where. Right. Over the course of the evening. And that's the level of thoroughness in the judgment. But with respect to the CCTV, it was closely scrutinised, and obviously, everyone gets excited about CCTV in cases because it's the only true truth, maybe a document probably that you can't, it's indisputable, assuming it actually is clear enough.
I'm just looking at an extra D of the judgment, and there are a bunch of stills here.
Yeah, well, that's the last 20 or 30 pages of the judgment, all these things. But here he said, Mr Lehrmann must have known that the relevant CCTV footage would be examined by some with the intensity that others analyse the Zapruder film. Now,
the what film?
The Zapruder film. So the Zapruder film is the 8mm film that was taken of the John F. Kennedy assassination.
Right.
And so that guy, Zapruder is his name, was filming 8mm footage of the cavalcade because it was just Kennedy, going through the town, and happened to capture this fateful, one of the most famous, moving images in history of John F. Kennedy tragically receiving that shot. But I like the term, again, the reference to the Zapruder film, because that has occupied so much fascination, almost a morbid fascination for people over the years. Similarly, the Higgins-Lehrmann trial and trials of this kind take on that significance for the audience. They have becomes this fascination with as much about there were so many personal details that had to come out, and it became this drama that everybody had this kind of quite weird fascination, because everybody you speak to had an opinion about it, and there was this similar level of fascination. So my point is that when the Justice Lee uses these references, they actually are really quite pithy, and they do capture something that he's trying to say back to us, or the public.
He made reference to Back to the Future as well, didn't he?
Oh no, he did. That was the other one that I quite liked. Did you like that?
I like that.
Well,
yeah.
you don't mind a popular culture reference, do you?
Well, I'm all pop culture, as you can tell.
So this one's a beauty, and that was actually, funnily enough, the other one that I wanted to mention.
Oh, right.
So the bar that they went to, but the first bar they were at was the Dock, apparently, or something like that. Maybe I could be wrong about that, but anyway, they were at a one bar, and then they went to another bar before they went back to Parliament.
There's now a Bruce Lehrmann reality tour now in Canberra that you can go on.
They went back to Parliament House.
You just got to get through that Parliament House. That's the hard one at the end, I think.
And there was only one or two drinks had at the last bar, and that bar was called 88 miles an hour, right? And so Justice Lee, obviously, it piqued his curiosity, as it may have. It did mine, because as I was reading judgment, I read the table of where the drinks were had and by whom they were bought and, what have you, and at what time they were had roughly. And then I got to 88 miles an hour. I thought, that's an interesting name for a place. Is that a typo? Of course it wasn't. It was intentional. And he says, So Justice Lee says he was also keen to continue the evening and his interactions with her, this is Mr Lehrmann, as events at the dock, were winding up. A plan was made for a group then to go to an 80s themed bar, my wife loves the 80s, she would know this off by heart, known as 88 miles per hour and located in the Canberra Civic. Although it does not matter, no evidence was adduced as to why the bar had this name. But one might speculate the owner was an aficionado of the popular 1985 film Back to the Future, where Marty McFly, open brackets Michael J. Fox, of course, close brackets, who can forget, travels in a DeLorean time machine from the 1950s back to the 1980s at that speed.
Wow.
Beautiful. Just a little aside there for you, just something. Because I read recently... Justice Lee is he's just finished hearing the ASIC prosecution of the Star City Casino directors for alleged breaches of directors' duties with respect to allegations of money laundering through the casino. And one of the article I read said he was going to have a break soon for 4 to 5 months, a well-earned break. Obviously, he's hearing a lot of big and difficult cases, writing long judgments, and that in that break, rather than like us mere mortals might think, oh, well, I'm going to lie in a deck chair for 4 to 5 months, he's going to write a film script. So this is...
so you think that could be the sequel?
Well, I don't know. Apparently it's about 1930s Sydney or Australia, and it's set in the time of the... obviously that's a Depression era. And I'm not sure, that was all that was said, but just interesting that the man of such great capacity, that his break is writing a film script.
You know what else was significant, though, in this judgment, and not taking away from any of those
I thought they were.
No, but what he...
You don't want to talk about the law, do you?
No, not the law necessarily, but I think this is really important, and at least given a lot of the trial really was a contest between... what Bruce Lehrmann had said occurred at various stages of the evening and Miss Higgins's recollection of events.
Yes.
There was quite a significant part of the judgment devoted to debunking some of these sexual assault myths that exist, that is all sexual assault complainants have one particular kind of reaction to events, or that their memories should be of a certain kind. And I thought the fact that his judgment touched on these issues, and also that he says that both parties agreed to a number of agreed facts about expert opinion on how survivors of sexual assault might retell their stories. I thought that was quite significant in the judgment.
There's a number of dimensions to it, isn't there?
There's so many dimensions to it.
We could actually do a whole show on it.
There's about 10 agreed facts. I won't read them to you, but they're really important, I think, for people, if you do want to look at the judgment, to sort of get a sense of how the parties managed to agree, at least through the practitioners, about how expert opinion on responses to sexual assault, and they're telling their stories, how that could affect their memory, and how to try and explain and account for perhaps some of the inconsistencies in Miss Higgins's version of events.
Yes. Because they would there was a big challenge to credit of both witnesses, obviously, and he wasn't satisfied entirely of either of the...
That's right, but what he said about that, which is a good point, he says, there is a significant difference, because he found Mr. Lehrmann to be not a witness of credit in many respects, not all respects, but in some respects. He says at paragraph 186, there is a significant difference between the distortions of Mr. Lehrmann and Miss Higgins. In the case of Mr. Lehrmann, the untruths were all over the shop, being a form of what might be called disorganised lying, whereas the untruths of Miss Higgins can be placed in two temporal categories, and were in the latter category quite organised, and within both categories generally had a common thread. So he definitely found distortions of truth in both of their accounts, but found that there was a coherent theme, it seems, in how he assessed Miss Higgins's evidence.
One of the other big things that Justice Lee was at pains to deal with was this idea of proof. and levels of satisfaction. Obviously, there's the very oft-cited decision of Briginshaw, and then followed up at High Court in
What's Briginshaw,
Neat
Nick?
Holdings. Briginshaw, well, this is a great question because I don't think anyone.
I know you're the law nerd of the show.
No, mate. We know that's you. But thank you, Justice Hamill, for those.
Yeah.
The idea behind with Briginshaw is the level of seriousness of the particular allegation, and it can apply in a civil case. Well, it applies in a civil case because in a criminal case, it's beyond reasonable doubt, which we know is a higher standard than the balance of probabilities in civil cases.
Yes.
The level of satisfaction that a court needs to reach in a civil trial when there is a serious allegation made, such as in the Lehrmann Higgins case of rape, needs to be higher than it would ordinarily be given the seriousness of the allegation. What that actually means in any sort of percentage terms analysis, is balance of probabilities 51-49? Does that take it to 60-40, to 70-30? Is anybody's guess, because level of satisfaction is a very, very nuanced thing.
Yes.
But it also comes down to cogency of proof. That's what the next level and the more accessible level at which Briginshaw has spoken about is if you are saying for example, you're asking the court to draw an inference that something happened, the level of satisfaction, perhaps the number of facts and the certainty with which they are proven or established would need to be greater than in, say, a charge for something run-of-the-mill like a negligence case.
Perhaps the best context to discuss this in, if you don't mind, Nicholas, is in the context of the Ben Roberts-Smith
Absolutely, good
judgment.
segue.
Because I think, in fact, when Justice Lee was writing his decision in Lehrmann trial, he had the benefit of Justice... he had the benefit of the first instance decision in the Ben Roberts-Smith trial,
yes,
which they went through a lot of these issues you're talking about. But I think given that since we last were on the show talking about some of these judgments, the full federal court, a judgment of Justices Perham, Katzman and Kennett, they've really gone into some of the nuances of how one needs to feel that actual state of
to
persuasion.
the tune of 1,000 paragraphs.
Well, that's
quite
true.
a judgment.
But I think it's important to talk about it because in that case, the imputations that were found at first instance have been conveyed and then found to be, I'll use the words of the judgment, substantially true.
Oh, yeah, and that's where it all starts.
Well,
this is where the debate begins.
What does substantial truth
What
mean?
is truth?
But just to give you a bit of context, I'm sure everyone is aware of it, but the imputations were, amongst other things, that Mr. Ben Roberts-Smith murdered an unarmed and defenceless Afghan civilian by kicking him off a cliff and procuring the soldiers under his command to shoot him, that he committed murder by pressuring a newly deployed and inexperienced SASR officer to execute an elderly unarmed Afghan in order to blood the rookie. Another one, for example, is committing a campaign of bullying, shooting an unarmed Afghan man with a prosthetic leg by machine gun, and then obviously encouraging, you might have heard this in the news, encouraging his team to drink beer from the prosthetic leg as a drinking vessel. So these are really serious imputations.
Briginshaw Central.
They are, and as we were talking about before, dignity. A man without dignity might be no one, or I say that in a gender neutral sense.
This has to be why Mr. Roberts-Smith sought to bring the defamation action, and so the media outlets had to satisfy the first instance judge and ultimately the Court of Appeal, as it turned out, that those allegations were there was enough evidence to support those allegations for the court to be satisfied on that higher standard that they were Was it substantially
true?
Substantially true.
And the full federal court, relying on a recent speech given by, a recent article authored by the Chief Justice of the High Court, Stephen Gagler, who says this.
Can I just... The name of the article, sorry to interrupt you, is great. Truth and Justice, and sheep. Sorry, just go on.
That's all right. But this is the point you were making earlier, Nicholas, wasn't it? The legal concept of truth is not absolute. I mean, one might think that truth is binary, but what this article is saying is the legal concept of truth is not absolute. It is a matter of degree. True or untrue, His Honour wrote, means proven or unproven, and is ultimately believed or not believed with the requisite degree of intensity. And obviously he went on to discuss the difference between a civil standard, the criminal standard, and the Briginshaw standard as codified by the Evidence Act, etc.
What I find interesting is that lawyers understand this, and I don't say that in any sort of snobbish way, that truth is a construct that relates to evidence. And it is only that good. It is not, the judge is not God. The judge doesn't get to go back and stand in the sky and look down at what happens and say, well, that's definitively what happened. The evidence says this versus evidence that may point against that. A choice needs to be made. That's as good as it gets. But what ends up happening...
And the evidence is filtered by rules of evidence.
Well, of course, and all of this stuff that goes on, and lawyers and the unreliability of certain witness testimony, the pressures of the courtroom, all the limitations that actually our system, but it's as good as we've come up with, has. Yet, when a decision is made, as it, for example, is in Ben Robert Smith, to the public's mind, and certainly the media does nothing to, and the affected media in that case, the defendants would obviously have no motivation in it being any other way, turn it into absolute truth. So it becomes, this is...
what happened?
This is undisputable, absolute categorical fact. And the reporting becomes that there's a naming. So you'll notice the headlines say "War Criminal Ben Robert Smith." He's not a convicted war criminal. He's not. That hasn't happened. It may not happen at all. But this is what happens. Is that this is, I guess, part of what we're talking about with media reporting of trials, and there's a danger to it as well, and the way they do it. It's probably always been the case, but I find that problematic because it's a matter of proof. It's not.
I mean, I think you're saying that, Nicholas, aren't you, in an abstracted sense, right?
I am, but I have a problem with it. Maybe I'm a bit of a purist.
No, you are a purist, and that's why I love you. Mm-hmm. But there would be plenty of people who would have read this judgment, or been in the trial, or been witnesses or participants in this legal proceeding, who would have found that the manner of his like in this particular case, his defence or the way in which he ran his sort of theory on what happened was implausible, and therefore he's actually still concealing the truth of it. And so maybe there'll be some out there that's saying that he hasn't been called out for everything that he ought to have done, because it can go both ways. But I think, but I understand your point, which is, I think, in a generalised sense, but also in this case, the headline carries the day. And in Bruce Lehrmann's case, and we weren't there, but the evidence has been just one person at the end of the day, with all of the legal training, has found the actual state of persuasion that this event occurred.
Briginshaw's not as high as beyond reasonable doubt, is it?
No, it's not.
It's not. So you say someone is for example, a war criminal. That hasn't been established, because if I think maybe if there had been a beyond reasonable doubt standard, one may be able to. But so there's anyway. I think the public don't care. Actually, I think the public just want shorthand.
No, I think the public cares, but the public don't have the appetite to get into the nuance necessarily because they're not either trained or the media doesn't quite give them the platform to do the critical analysis that we're trying to bring to the world, probably through the show, I suppose, at times. But for what I found interesting about the Bruce Lehrmann, going back for a moment, was that the next day the headlines were rapist. Right?
Yeah,
now,
I mean, that's...
And now that's...
But Justice Lee was at pains to point out that wasn't the effect of his finding, and that's the thing as well. It's just that the evidence was sufficient to establish, that that's, for want of, a better result, that he has to find one way or another,
well,
doesn't he, on the line of it?
I thought his point was that it's not a mechanistic application of probabilities, like 51, 49, okay, I've got this much evidence saying this, I've got this much evidence. It's assessed as a whole, and I think if you, to be fair, Nick, I think if you drill down on his outcome, he does conclude that she must not have been consenting at the time of the relevant event, and that event carries with it one only implication, that he engaged in some kind of intercourse without consent.
Vasi, it just goes to show how important credit is, and you know that from your own experience. It's rare that you win a case, certainly not like that, and perhaps even impossible if you your witness doesn't come up to proof.
And in fact, and this is the point that the full federal court made in Ben Roberts-Smith on credit. They made a finding that Mr. Roberts-Smith had attempted to intimidate various soldiers into not giving evidence or into changing evidence, but also that he concealed a USB stick, which he kept in a lunchbox and buried in his garden, which might have had incriminating evidence. And what the court went on to say is that the court was very blunt about Ben Roberts-Smith's credibility. In fact, they said in relation to both the concealment of the USB stick and also attempting to intimidate those persons unnamed giving evidence, that they are serious and they reflect badly on the appellant. Now, credit is everything, and in a very different context. In some of the family law work I do, Nicholas, I say, look, if you're dishonest about $1, be prepared to lose $100,000. Yeah. Because it's all about once your credibility is contaminated, your whole case is contaminated.
Even the most valuable piece of evidence you might give in respect of your case becomes devalued to the point of it won't assist you. So, and it's a massive thing, and obviously that's what really ultimately decided, and was always going to decide both the cases in Lehrmann and Ben Roberts-Smith, is the trial judge had to make a choice between the two. In this case, the media outlet against Ben Roberts-Smith and what they put forward, and the other, and obviously it was really a word v word case. There was a side issue with it as well. There was this whole notion of cover up that apparently Channel 10 had.
Yeah, but then there's that whole concept that Justice Lee speaks about disorganised lying, because ultimately your lies need to sit in the context of the objective facts. Yeah. And when he knew, for example, the CCTV would show something else, and the unexplained positions he took were perhaps fanciful, at least by the judge's decision. Yeah,
big and interesting decisions.
But you're right, Nicholas. Like, they're not convicted of any criminal charge.
No, and this is the thing, and this is what happens though, and this is the risk, I guess, which will chasten. I think big, and it's been said, big defamation litigation is. The risk is that on a civil standard, the truth of the substantial truth of the imputations is in fact established in court, and you're then stuck with them, but even worse, because you're it sort of magnifies them in a sense. So it's a big risk, and it actually brings me to another development in law recent. This new statutory tort of privacy.
Yes.
Breach of privacy. Now, it's not new in a sense that it's new that it's accepted as a tort. There's been some argument about whether it's something that should more reasonably lie in equity. That doesn't matter for the purpose of this discussion.
Are we? Can I ask you, at least for some of our listeners, to explain basically what a tort is as well? Is it worth doing that?
Oh, it's a civil wrong in a nutshell. Yeah.
Well, what does that mean? Yeah.
Well, it's such a broad notion, isn't it? Yeah. A tort, but it's. I actually couldn't even venture anything better than a civil wrong for current purposes.
I think.
Try.
Oh, let me try. I mean, it's basically where the law has developed in a way to protect people from wrongs committed upon each other. So yes, a civil wrong between you and I. So if I was to punch you, obviously the criminal law regulates that through statute because that would say that that's an assault. But before or contemporaneous to the criminal law, your right to not be hit by me is protected at general law.
Yeah.
General law, common law principles that says I shouldn't unlawfully punch you, or similar to the tort of false imprisonment that we spoke about with in the Stratford decision. You have torts of trespassers. You have torts of negligence.
It's an action that to me takes its meaning from by comparison, like contract something written down. Tort something, a right recognised of a more general nature that emerges organically through legal precedent.
And why I think it's interesting to have that start there, Nick, is because one thinks about, we talk about dignity and what a breach of privacy, much to do with dignity, right? And yet one of our most sacred possessions, our dignity or our
inalienable rights,
inalienable rights, has never been protected by a recognised tort. You've always had to rely on defamation. Sorry, I digress, but I just wanted to.
So take... there's two kind of seems to be two ways you can go with it. The statute. There's this idea of a breach of your right to seclusion. So that would be, for example, would it? You're sitting in your backyard, or sunbaking. And someone flies a drone over your backyard and takes a film of it and puts it on the internet.
Yes, sounds like an example.
You've made it clear, because this is part of is a reasonable expectation component to it, to privacy. You've made it clear that you're in the privacy of your own home. You're between the four, your fence, and so you've secluded yourself as such. You're entitled to expect that you can do that without someone filming you and posting you in our case, our less than desirable physical specimen on the internet, and that would cause you some considerable degree of humiliation, i.e. loss of your dignity. So,
but is that different to reputation?
And there's that just before and then there's this idea of misuse of your information, your private information, being, obviously, again, something private about you that you have decided you want to keep confidential, you wish to keep confidential. It could well be a photo of you that you have yourself, you've kept somewhere that someone then publishes, or film, for example. It might extend to say two lovers, I mean, this might be a little bit controversial, but two lovers, film themselves, and it's obviously understood that was for them, something that they would do, but one of them then, after the breakup, decides to go and publish it somewhere to humiliate.
Well, I think that's also criminally sanctioned as well.
Well, it is, but to give it, but how do you get damages? Because this is the idea of, and this is something that's come out of the legislation to me, which I've got a question in my mind about, because damages, so the damages arise from effectively, save for, if there hasn't been an economic loss, for example, if you hadn't, and often there won't be, where most people who would have had a loss of, unless you're famous, for example, probably won't have anything they can call upon where they, look, maybe if you lost your job because someone published a photo of you in your backyard sunbaking on a day you're meant to be
just physically distressed.
Meant to be at work.
You could suffer a psychiatric illness.
Well, but this is my point. Or I suppose so. But a lot of the time, it might just be hurt feelings. And what are the damages for hurt feelings? So this will be what, in my view, distinguishes the cases that make it to court, where there are a substantial level of loss. Because otherwise, what's the point of doing it? Or do people do it to protect their reputation?
Going back to the definition of tort, right? And some of those examples about battery and assault and trespass, they're, to use a legal term, we are a legal show after all, they're actionable per se, i.e. you don't need to prove that you've lost anything to start it. So
that's
why,
part of the legislation.
So why you would bring it potentially is anticipatory. So if you have a substantive right that's being breached,
you bring it by way of an injunction.
You can bring an injunction.
I
think, and especially in the world where everyone's got your data, or you might find that someone is blackmailing you or threatening you with releasing information about you that's only unique to you. I could imagine that the duty list judge might hear an application by a summons and says, look, this person's about to do this, or an injunction. Now,
absolutely.
So I think that's pretty important.
They must have undertaken a very wide array of consultation as well, because there's obviously some really important, there was Lena Game meets, it's been alluded to or hinted at by the High Court in the past. There was quite a recent Victorian case, I think it was Waller, was it, where it was actually recognised at common law, but the judge refused to say whether it was whether it was tortious or equitable.
It's a Victorian decision.
Yeah, Waller. But they also would have called upon the sort of past decisions of other sort of, I wouldn't call them lesser lights. I actually found a decision by Ahmad J.
Oh my goodness!
Justice Awais Ahmad, in the case of Alison Robin Gross and Robert James Purvis.
How did you
Counsel get that? Gillian Burnside was appearing in that case. Apparently, this is a very important and not often referred to case. It has the hallmarks of a university assignment, which may well have been written by one Ahmad A. Elephant Ahmad A. sitting as a judge. And so you, Vasi, for your sins, had foolishly handed this over to me in the context of our discussion prior to the show.
I thought I might educate you.
It reminded me, because when I was talking, we were talking about judicial flourish and how much I like it. I couldn't go past the opening to Ahmad J's judgment on privacy. So this is a judgment that Ahmad J wrote sitting then as he was at university about the tort of privacy, or the right of privacy. 2005. What the visionary that he was, that he actually captured, obviously great reference to all the decisions, including Lena Game meets, all the critical case law, and came down on the side of to allow the appeal and find that the right of privacy existed here. But let me just open with this piece this is Ahmad J's opening. The tort of an invasion of privacy in the intellectual history of Australian law resembles that of an unripened piece of fruit lying in a woven basket. It has been picked at, it has been poked at, yet all have avoided eating it in the fear of experiencing an overly sour taste. Stop. In my mind, the current circumstances are such that the time to pierce the skin of this fruit has arrived. Ahmad J, sitting on high, I agree wholly with the notion that a man without privacy is a man or woman without dignity. Each intrusion upon private life is demeaning not only to the dignity and spirit of the individual, but also the integrity of society of which the individual is part. It is apt to recall the comments of Rich J in 1937, which has far-reaching implications in contemporary society. The quote goes thus: "The prospects of television make our present decision a very important one, and I venture to think that the advance of that art may force the courts to recognise the protection against the complete exposure of the doings of the individual may be a right indispensable to the enjoyment of life." Isn't that very... So Rich J sitting back in 1937, but then Ahmad J sitting back in, what was it, 2005, have foreseen the future, haven't they? And they've really...
Putting the joke aside about that judgment, if I say so myself, it's quite apt what Justice Richard said, because...
I thought you were going to say what Duke said.
In 1937, he's worried about what television's going to do.
And here we are.
And here we are in 2025, where the only way in which we consume information, I withdraw that, the primary way in which we consume information is social media.
Can you say I withdraw that in conversation?
Yeah.
Can you, please?
You're
giving the bar a bad reputation.
It's the best
you
thing you can do.
say that in general conversation.
Do you know how many things I withdraw at home in conversations with my wife?
Drive your mum absolutely crazy.
My mum and my wife.
And your mum. Your wife. Absolutely crazy. Sorry, go on.
The beauty about withdrawing things in court is you can say the most outlandish thing, and if you say those magical words...
And it sets it at naught. It's like you never said it.
Oh, he withdrew it.
Yeah, he withdrew it.
Yeah. And you hear these huge objections, but he withdrew it. Anyway, back to...
judicial speak and general conversation.
But we're in a world now where, I think it's a really interesting time, and I think it's really important that the tort be recognised. But I just want to say something. That university assignment, that was... I
thought you were going to talk about the tort. But
No. I want to talk about someone far more important to me. There was... that was in advanced torts, a subject that I studied in fourth year university, roughly around 2005, I think. It was taught by a senior academic, Penelope Watson. She was the most adored and loved academic at that university, and the reason why I want to pay tribute to her is because she tragically died in 2017 of cancer. She did so much for all of us at that university, especially around understanding the common law on privacy, issues like the intentional infliction of emotional distress. She was an expert in dust diseases, and it just, when I was looking at this tort, I thought, if she were alive today, she would be certainly embracing it, teaching it, talking about it. And
she certainly did a great job, Bussy, because to be fair, I did read it, might surprise you to know, and it's actually a very good assignment. I don't know what score you got, but I'm sure it was, you're going to say in high distinction, but anyway. So that's been another important development. There's a number of tests. It's going to be really interesting to see how it goes. There's a lot of tests built into tests within a test.
Yes.
And I just really, and they have, interestingly, there seems to be a room for a lot of norms, societal norm, notions of societal norms, which you'll recall something we spoke about with ex-Justice James Alsop.
Yes.
About the importance of societal norms being brought into judicial decision making, and it did strike me that this is something that's very, as you say, timely, but of great contemporary relevance, and it'll be very interesting to see how the judges handle these cases that are going to inevitably come out of this, and how they incorporate societal norms as they currently stand into their decision making.
Yeah, because I can imagine plenty of advocates saying, an invasion of privacy when you see it, getting bogged down in these it's a statutory tort, so it's been codified. Broken down in various elements. You have to give faith to the statute, but ultimately it sounds very much like a value-based societal norms type judgment that one's going to have to go through.
So just moving on, watch this space indeed, and we will revisit it as things develop, and I look forward to seeing some decisions and how the judges fall. And so just moving on to another pet topic of yours, direct speech in judgments.
Well,
there's been a judgment on that recently, hasn't there?
Yes, thank you for giving me the time on that. Just since we last spoke about the decision of Justice Jackman in Cane High, there was a brother of Wolverine, as we discussed. The short point is that direct speech in affidavits is back.
It's back. It's back. Oh, good. Who said?
Well, the Chief Justice said.
Well, the Chief Justice says it is back, isn't it?
Yes, well, along with Justice White and Chief Justice Bell, who go into depth in it. In fact,
so we're now all doing our affidavits again with direct speech in them rather than...
I think the point that they were making in that decision was that whatever New South Wales was doing in the past, it was doing it right. And the criticism that Justice Jackman has posited, and some have followed, that if you are going to put your affidavits, your evidence of conversations in an affidavit in direct speech, it better be the actual words, or you need to then make it very clear that what you're producing is the gist of it. The position, at least in New South Wales in the Court of Appeal, is that how we were always doing it made that plainly clear anyway. But to
get the pedantry of these form objections, you've seen in your objections to an affidavit, because it's been he said to me that he thought that it was a very impressive podcast, and he didn't ever no one for example just thinking aloud.
Sure.
And we didn't say it comes in a paragraph. It's not all separated out. It doesn't have words to the effect of. Is a form objection to that going to be just kills that statement, and we don't get that into evidence?
Well, if we're talking about form, one of the reasons why this practice developed into he said, she said, I said, who said, is to avoid the form objection.
So, Vasi, there's also been some missives from the high powers regarding AI.
There's been
a practice note issued by the Chief Justice of the Supreme Court about the use of AI in litigation. Obviously, we know.
Do you use it?
I use it to do two things at the moment. Principally one, I use it mostly through Acrobat Professional.
Right.
I love its ability to
We're not sponsored by
summarise judgments and even other documents that it recognises. Okay. It provides it's great. For example, some of my cases I've read very long expert reports, and it just helps you to find things in it. So it'll say, what does the expert say about blah, and it'll just go there.
You do that through Acrobat?
Yeah, and it's the AI assistance as a bolt-on to the main program. So I use it a lot for that. But I can imagine that AI, obviously Google's built it in now. So you say, tell me about preliminary discovery in New South Wales. It'll go through and give you a set of quite neat points, how the right to it is established, or in the case of a tort, a cause of action, and then cross-references where it's founded. And often it'll be, because you know how law firms, for example, will write a piece and publish it on the internet. Someone will say, this is what, there was a decision in preliminary discovery, and it cross-references those, and those have got case law built into them. I wonder if we're not going to see with AI the rise of the self-represented litigant, where they think, some people, educated people think, at least maybe even for smaller cases, why can't I just do this myself? So anyway, that was just a side.
There's plenty to be said about it, because I saw this anecdote the other day that says if you're not using artificial intelligence by now, it's effectively like people all driving cars and you're still using a horse wagon. Things are really moving in this space. Some of the apps are very intelligent, very creative, but often with that comes a lot of dangers. I read an article, I think a head note, the wonderful head note that summarises things that are going on in the law, drew my attention to an article called Periodolic illusions of meaning, ChatGPT, pseudo-law, and the triumph of form over substance. So to your point about the self-represented litigant, sometimes when you read words, I think this is what the article's getting at, when you read words in a forum like ChatGPT and it explains things in a very intelligent, articulate way, you sometimes get sucked into the form of what's being said, and that becomes your understanding of the law as opposed to the underlying doctrinal analysis, which is probably what the real danger is, isn't it, when we get to excessive use of artificial intelligence?
Yeah, I mean, the practice note basically, affidavits and expert reports it seems to focus on, it can't be used in the context of preparing those evidence.
But you can use it
you can use it for submissions, chronologies.
You can use it in submissions, but you must verify how you've used it.
Yeah, of course. And you would, wouldn't you?
Of course, but it's just, and obviously lots of people are getting in trouble because sometimes you're relying on ChatGPT, and I think a practitioner in America had made up cases because the AI had hallucinations.
Of course, these kind of hallucinations.
Well, my kind of hallucinations.
Yeah, right.
Speaking of hallucinations, let's give it a test. I thought one of the things we're doing today is talking about the Family Law Amendment Act.
Yeah.
And in short, I can tell you, on the 10th of June, Family Law Act changed it again following another response inquiry into how effective it is. It's made a lot of changes in relation to property this time. The last round was about amending matters to do with children. Property disputes are now being resolved by a far more coherent, structured statutory mechanism. And one of the issues that they're codifying is the effect of family violence on a dispute about property. So they're looking into it.
What's the case about that? Or what are they called? What's that application called? A Marcus? Or Kennan, Kennan.
A Kennan claim historically permitted for the courts to take into account when you're sorting out a contributions-based analysis, i.e., let's go back to the beginning. How do you work out what you get in property? You work out what you put into the asset pool, and that includes.
Sorry, the violence aspect is how does it play into?
I'm getting into it. So you have to identify what your contributions were to the welfare of the family, and if your contributions to the welfare of the family were, in the words of those authorities that followed it, more arduous because you were exposed to family violence in a way in which made your daily tasks harder,
or your ability to go to work harder because you were being abused, or you were being damaged in some way to disenable you from contributing by going to work, for example.
All of those things.
Yeah. So that's quite a complex sort of concept, isn't it?
And the thing is, when you have a family law definition of family violence that is rightfully very broad and encompasses a whole range of conduct, what we're seeing as family law practitioners, or what we think we'll see as family law practitioners, especially given that there's been statutory codification of it, is that cases will get harder and more complex.
So this is a codification of Kennan, is it?
Okay, among other things. But look, don't take my word for it. Let's see what ChatGPT says. In fact, use the dictation button. Please tell me. Let me try again. Please tell me what are the amendments in the Family Law Act and how will it change practicing in the area? Hang on, it's loading.
There's a lot of them, Bussy. You cast a fairly wide net though there.
Well, I mean, we can summarise it, but
why don't you? Yeah.
Okay, so in short, greater focus on family violence and safety. It gives you a bunch of practical tips. It gives you a whole bunch of information here that I've basically just discussed.
Yeah, exactly.
Pretty open.
To my point, you're going to get people, someone could put that in, and do you know what also might happen is clients are going to be second-guessing lawyers more, because they're going to say, well, I put this into ChatGPT and it says this is the answer. you've put this in your submissions or your arguments to the court. I actually didn't agree with that because I would have done it this way.
Well, it's probably like doctors now, right? Every time you go to the doctor, you've already diagnosed yourself.
You're going to create all these armchair experts who are your clients. They're going to say, well, I don't think you've done a very good... It's a dangerous situation, isn't it?
It's a dangerous situation, but there are some parts of ChatGPT that are fun and worthwhile talking about. In fact, just this morning, something I prepared earlier, Nick, and depending on whether you wanted to close out here, I wanted to play for you a wonderful rap.
Yeah, I had one other thing to say after this. If you want to close out with the rap.
Let's close out with the rap.
Do you want to close out? Because I wanted to, I was just looking at thumbing through Barney's. I just wanted to, we mentioned the great Tom Hughes, Thomas, I love his middle names, Air Forrest Hughes. He passed at the end of last year. There's a great piece written by recently retired Supreme Court Judge John Sackar, AMKC,
yes.
And it just described beautifully what some of the advocates of his era, what were sort of valued. And I think it's different, it's changed now. I think what's valued in advocacy and what is sort of, times have changed. He was very much a man of his sort of times, Tom Hughes, but it's interesting. He quotes this Australian Financial Review article about his description of him, and I think it's good to pay tribute to the likes of Tom Hughes and these greats of yesteryear and how we've talked about things have changed at the bar. Meticulous preparation, rich vocal pitch, penchant for the pregnant pause, a thing that's been lost a bit. I'd never have the guts to use it.
A penchant pause.
A pregnant pause.
A pregnant pause.
Flashing eye, imperious mien, razor-sharp mind, brutal cross-examination, pomposity, wit, apposite quotes from the bard, the likes of which we see in some of these judgments, which I think there should be more of, all have a mesmerising effect in the courtroom. That style of advocacy, I just think it was a beautiful description. But he goes on to say in this article, this is ex-Judge Justice Sackar, but for those of us lucky enough to have worked with him, there was so much more to Tom. I love that. You've got this glowing appraisal of him, and Justice Sackar, as he was, he says, but there was so much more. So, yeah.
I can't imagine the late Tom Hughes consulting ChatGPT for anything.
No, exactly. And this is exactly how things have changed. But what have you got for us, Fuzzy?
But what I did today was you can have a lot of fun with having ChatGPT write about yourselves. And I thought to myself, well, let's ask ChatGPT to write a song about us.
Yeah. Is this another shameless self-promotion exercise we're engaging in?
Not necessarily. And play it to the voice of Taylor Swift.
Oh, well. I can't wait to hear this. What do you got?
Here we go.
Nick Hogan, Ava's Ahmad. Let's go. Truth in the courtroom they don't want to show. We ride that fence, don't throw the line. Justice in shadows? That spotlight's mine. Yeah, we see that elephant, sitting real still. Pushed up truth that they don't want to spill. We sat between Jackman and Chief Bell, debating affidavits and direct speech spells. One supreme, one federal, real deep game. Overeen's brother? Yeah, remember the name. Margaret Kinane, told it like it is. Criminal trials. That courtroom biz. James Alsop came, taught us what's fair. Unconscionability, right there in the chair. Hamill dropped real on the mental toll. Judicial weight? It can swallow you whole. Walmsley chilled, lamb cutlets, true. Gas vibes with a barrister's view.
There you go. Well, there you go.
See, I'm not really sure what to make of that.
We just need to get some beats behind it.
I would put some beats behind it. I might, but there's possibly some accent issues there.
Well, it definitely wasn't a great Taylor Swift.
I'd like to hear a thicker Australian twang to whatever that is.
Well, there are limitations to artificial intelligence.
Yeah, right.
What have you got here, mate?
Mate, the other thing is I've sort of done my advocate's quote, but this is a book that we share a love of, and this is Marcus Aurelius's Meditations, and I sort of sometimes look for these. This is full of great quotes. I mean, obviously Marcus Aurelius was a Stoic, and I think there's a lot to be learned for barristers about the practice at the bar and there's a lot of parallels with Stoicism, and learning to separate yourself emotionally sometimes from the difficulty of your cases. And I just love, there's many in this book, but I thought I'd just share one to end off with, which is, he must have written this when he was in battle because he was obviously a general, wasn't he, in the Roman army. And this is from book 2 on the River Gran among the Quadi. I don't know if I'm pronouncing that correctly, but he was battling those tribes at that time, and he obviously did writing when he was in the field, and he wrote, concentrate every minute like a Roman on doing what's in front of you with precise and genuine seriousness, tenderly, willingly, with justice, and on freeing yourself from all other distractions. Yes, you can. If you do everything as if it were the last thing you were doing in your life and stop being aimless, letting your emotions override your mind tells you, stop being hypocritical, self-centred, irritable. You see how few things you have to do to live a satisfying and reverent life? ? If you can manage this, that's all even the gods can ask of you.
Wow. Very good.
Mate, it's been great to share it with you today.
Thank you, Nicholas, for joining me.
And we'll see you next time, everyone. Thank you for hearing us and for letting us share with you. Bye for now.
Welcome to the room where the echoes stay quiet, where robes walk heavy and the truth stay private. But Nick and Ava's cracked the door just a bit. Let the mic hit the bench where the brave never sit. They're speaking on the gems that no one will flex. In the courtroom silence they dissect the complex. The topic's too raw, too real to pretend. But if justice is blind, then this podcast will end. It's the elephant in the courtroom, saying what they won't, lighting up the dark room. From the shadows of the bench to the jurors in bloom. This ain't just talk, it's truth in the courtroom. It's bold, it's real, it's raw, it's new, but tasteful enough to earn respect too. We're scared, but we're doing it right, shining that torch through the courtroom night. Hugh and Margaret Canine, fierce on both sides, crown and defense, she walks those tides. Tells us the truth of the trials no one shows, where the law meets trauma and humanity glows. Sexual assault, she don't sugar the tale, speaks of fragility behind the cross-exam veil. It's not just black letter, it's blood, sweat and soul, a human condition in illegal control. Justice Bell versus Jackman, affidavit fight, one says quoted direct, the other says not quite. Jackman, yeah, Hughes bro, not just for show, says gist is okay if you just don't know. It's a duel of minds from the robe elite, one wants verbatim, one wants clean and neat. Who's right, who knows, but it's deep in sight. That elephant unpacks every Thursday night. Now, Peter Hammer with the soul of a sage speaks of the mental toll from the dock to the stage, the weight of justice, the silence, the grind, what it costs to keep a clear judicial mind. Then all sop drops in with a cerebral flame, left brain versus tax enemy in the game. Can creativity thrive in a structure so tight? He says nuance is key, not just wrong or right. And don't forget Walmsley with wit so crisp, lamb cutlets and yaz with the justice's twist. He sees the court like a theater of thought where humor and hunger still have a spot. It's the elephant in the courtroom, no secrets safe in this tight war room. A bit scared, yeah, but we walk that line between fearless truth and being refined. Not just for lawyers, but for those who feel that justice is more than just ink and seal. Like Nick and Ava's edging class entwined, changing the game one verdict at a time. It's the elephant in the courtroom.